Good afternoon. Good afternoon, everyone. A quick query to our presenters. Are we ready to start?
Yeah, we'll.
Wonderful. Okay, so we'll get going now. So, good afternoon, Justice Adderley, Acting President of our Court of Appeal. Good afternoon, Justice Groucho. Good afternoon, Acting Judge Hatman. Good afternoon to our Acting Chief Magistrate Campbell and to our Deputy Registrar, Ms. Skippings. Good afternoon to all members of the bar who have joined us today. I see Chief Justice Winder just joined us. Good afternoon, Chief Justice Winder. Good afternoon to all members of our police force who have joined us. I'm informed that the Commissioner of Police, Mr. Trevor Botting, will join us very shortly. My name is Aisha Jifu. I'm the Secretary to the Turks and Caicos Islands Judicial Education Institute. A very warm welcome to today's session entitled Unpacking New Legislation. With the assistance of our presenters today, we will unpack two new ordinances, both of which very recently came into operation last month on Monday, the 7th of November. The first ordinance we will be exploring today is the Interception of Communications Ordinance 2022. This will be a joint presentation by Mr. Andrew Mitchell, King's Counsel, and by Mr. Quinn Hawkins. Together, Mr. Mitchell and Mr. Hawkins have over 50 years of experience at the bar. Descriptions of their wide-ranging careers are contained in this circulated program. But to give you a snapshot, Mr. Mitchell's experience with a similar iteration of the Interception of Communications Ordinance in England comes from his experience where security services were involved in collating and collecting intercept. Much of his practice has involved matters related to the proceeds of crime. He has advised and/or represented government authorities seeking restraint and forfeiture of criminal proceeds, as well as private litigants opposing such process. He has also represented the governments of South Africa and India in the Court of Appeal in England and Wales and the House of Lords in relation to matters touching and concerning proceeds of crime. Regionally, he's admitted to practice in Grenada, the BVI, and the Turks and Caicos, and he has appeared before the courts in the British Virgin Islands, Grenada, Trinidad and Tobago, Cayman Islands, and here in the Turks and Caicos Islands. Mr. Quinn Hawkins is a barrister with over 20 years experience at the Bar of England and Wales and 7 years experience in the Turks and Caicos Islands. His practice has involved prosecuting and defending cases against serious crime and the proceeds of crime. He has been graded in the top tier of prosecutors by the Crown Prosecution Service and placed on specialist prosecution panels for serious organized crime, proceeds of crime, and fraud. Okay, so that's the first ordinance we'll be exploring. The second ordinance we will be considering today is the Anti-Gang Ordinance 2022. And Mr. Rajiv Prasad, the head of Alum Chambers in Port of Spain, Trinidad and Tobago, will be assisting us with exploring this piece of legislation, which is new to the Turks and Caicos Islands, but is familiar territory in Trinidad and Tobago. Mr. Prasad has provided advice on the anti-gang bill in Mr. Prasad has provided advice on the anti-gang bill in 2011 in Trinidad and Tobago on behalf of the Criminal Bar Association of Trinidad and Tobago when the bill was being debated. Since the implementation of the Anti-Gang Act in Trinidad and Tobago, he has advised and represented persons charged with offences under the Act. Mr. Prasad was called to the bar of Trinidad and Tobago in 1997 and is also admitted to practice in Antigua and Barbuda and Grenada. He has wide-ranging experience in criminal law and public law matters and has appeared in high-profile corruption and drug trafficking matters in Trinidad and Tobago. He's acted as a judge in the High Court several times regionally, serving in Montserrat, the British Virgin Islands, St. Vincent and the Grenadines, Grenada, and his native Trinidad. He's also well-versed in sharing his wealth of experience and has presented in many training seminars to various criminal justice stakeholders throughout the Caribbean. So you'll see that this session will be recorded, and our presenters have very kindly agreed to make their presentations available to us afterwards. These presentations will be circulated to all attendees. You'll be welcome to ask any questions of our presenters, and to do so, I ask that you raise your hand electronically, or you submit your questions to the chat and they'll come to the presenter's attention. So we look forward to a very vibrant and engaging session. So Mr. Mitchell, King's Counsel, and Mr. Hawkins, I now hand over to you to begin the discussion of the Interception of Communication Ordinance.
Thank you, Aisha. I hope that you have allowed me to share the screen.
Yes.
So that I'm hoping that on the screen now you can see the title page. Hello?
No, actually, I can't.
So then let me see how we're going to do that. I may need to stop what I'm doing, share screen, then do that. Does that work?
I see your screen now, Mr. Mitchell. Thank you.
Excellent. Can I please, everybody, adopt Aisha's introductions and say on behalf of Quinn and myself, what a great pleasure it is to see so many people join us on this Friday afternoon, particularly when I see that Brazil have just kicked off in the World Cup. We're going to talk about the Interception of Communications Ordinance. It's going by necessity to be a 30,000-foot review of the legislation because it is complex and involved, as you'll see as I go through the slides. What we propose to do at the end is A, send you this PowerPoint, B, the three cases that Quinn will refer to during the course of our presentation, C, the relevant provisions of the Regulation of Investigatory Powers Act from 2000 in England and Wales, and also the Investigatory Powers Act of 2016 from England and Wales, because this new ordinance, which we're going to call ICO, is based on that legislation. So it's going to be useful to have that because we will also send through a spreadsheet which lists all the sections of ICO, lists the relevant sections of the IPA from England and Wales and RIPA, together with, for those of you that may need it, references to where any of those sections have been discussed in Archibald. So we hope that that will be useful for you. Now, the telecommunications infrastructure has, over the years, been used to plan and carry out unlawful activity. And of course, up until this legislation was passed, a court might have been able to order providers to provide details of phone calls made, phone calls received, and their locations. In other words, the printout. together with cell sites. But it has been considered and now passed by the House of Assembly, necessary for the Turks and Caicos Islands to have a more comprehensive, transparent, and modern approach to the interception of telecommunications. It achieves two purposes. It allows for, in circumstances which we'll come to, the interception of communications. All those intercepted communications, particularly and if they are phone calls, are not ever going to be admitted in evidence. So that's going to be an interesting part of what we discuss, because it also permits the gathering of intelligence, therefore, in that way, as well as interference with postal network. And we'll come to the postal network because it's quite important for particularly those that use couriers to realize that references within this legislation to postal network or a public postal system includes couriers, includes FedEx and DHL, by way of example. Now, the ordinance is in 7 parts. It is 78 sections. It is meant to provide a legal framework for law enforcement and intelligence agencies to use their investigative powers to obtain access to the kind of communications which I have already referenced and postal material. The powers cover the interception of the communications, the retention and acquisition of communications data, and the use of equipment to interfere with data. So in other words, to pick up data and communications. It also deals with, incidentally, the legality and illegality of communications equipment. So some equipment is no longer lawful to hold. So it is now lawful under the scheme to intercept in the Turks and Caicos Islands a communication in the course of its transmission. But it is not lawful to do so without lawful authority. And this applies to all communications in the course of transmission through the public telecommunications system, a private telecommunications system, and as I've already said, the public postal service, which I emphasize includes a courier. What is now listed on the screen is the first half of the list of offences. So in other words, this scheme only applies when the investigation relates to what I'm going to describe as serious crime or serious organized crime. And you will immediately see from the first 8, I'm not going to take time to read them out, that they are all issues which are of particular concern and relevance to us in our day-to-day lives. I don't mean each of us individually, but I mean in the way that it is currently affecting society. And you can see further the second part of that list on the screen. And of course, at 60, which I've emboldened, attempting or conspiring to commit, aiding, abetting, counselling, or procuring the commission of any of the offences which have been listed are also included as part of the raison d'etre for this legislation. I highlight, by the way, references to the Proceeds of Crime Ordinance on the earlier page, the Integrity Commission on this page, and of course the new anti-gang ordinance, which my brother Prasad will refer to. And Rajiv, it's nice and thank you for joining us to have you along and to hear your experiences. I've said the Act is divided into 7 parts. I think one of the things that it's worth discussing as we go through this is to recognize that until the legislation was passed, there may have been some discussion to be had about whether or not interference or interception was itself a lawful activity, because there was nothing to say that it was illegal, and whether or not in controlled circumstances and in the public interest, there was the ability to seek an order from the court to do so. Bearing in mind that we're a common law jurisdiction, and therefore everything is presumed to be right unless the law otherwise says so. There is a big discussion to be had, but it's gone, and the discussion is behind us, if only because it's important that this is regulated in a way that structures the rights of the authorities and those who are authorized to be able to apply to a court without having any concerns or worries about arguing the rights of the individual. So we now have a fully codified structure. It allows for interception from a investigative point of view, but not, as you will find as we go through this rather interestingly, from an evidence gathering point of view. So interception, as you can see, and I'm hoping that as I'm talking, you're taking the opportunity to read what's on the screen, if multitasking permits that, as well as for those of you that might be keeping a keen eye on the football. Section 3 defines interception. It defines interception by breaking it down into 3 elements. A person must perform a relevant act, which of course includes modifying or interfering with the telecommunications system. The relevant act must be to make the content of the communication available to a person who's not the sender or intended recipient. So in other words, clear interception. The content must be made available at a relevant time, which means when it is being transmitted or any time when the communication is stored in or by a system. The interception includes obtaining stored communications, such as messages stored on phones and tablets and other individual devices, whether before or after they are sent. Now, let's make clear from the start, there are offences. Although prosecutions can only be brought with the consent of the DPP, it is an offence to intercept a public or private telecommunications system or the postal service. And if you do so without a warrant obtained under the Act, you face an unlimited fine, 7 years imprisonment, or both, following conviction on indictment. Section 8, and I'm afraid for those of you from the Crown, from the DPP's office, or anybody holding an office under the Crown, anybody employed by the Royal Turks and Caicos Island Police Service, or anybody working within Digicel or Flow, who knowingly or recklessly obtain communications data, are liable to be sent to prison or fined $50,000. Now, of course, there are exclusions, and I've done this slightly lightheartedly because Section 4, of course, says that it is not an interception if you intercept something during its public broadcast. I suppose it needed to say that, for otherwise, if you were watching television or listening to the radio, you could be said to be intercepting a telecommunication. Conduct in relation to postal data, as you can see on the screen, is also excluded if the postman or the DHL delivery man or the courier reads the address on the outside of the letter in order to ensure it's delivered. But that's the detail of the way that this legislation has been codified. I've jumped ahead because it's important in the context of what's to come to realize that no evidence can be adduced in court, no question asked, assertion or disclosure made for the purposes of or in connection with any legal proceedings that discloses anything that is, and I'm summarizing this, intercept related. You can't ask a question, you can't hint, you can't introduce any idea that there has been an intercept. However, there can be, section 45, disclosure of communications for these purposes. And it is quite important for those of you online who are prosecutors to recognize that if you learn of the existence of a disclosure, the content of an intercept in the context of a criminal trial, where that content might mean that something that is being said or done in the trial is misleading, you will have a duty to ensure fairness in the proceedings. The judge similarly, either learning of an intercept and then making an order to find out what it was that was heard, may also intervene in that and order that there be some sort of disclosure. Our view, by the way, ignoring incidentally that we think there's a typo in sections 44, 8, and 9, our view incidentally is that this is where the prosecutor's duty to ensure fairness of the trial would mean that if, for example, the intercept disclosed that A had said that and I'm going to deal with it on a drugs basis, that the drugs were going to be supplied by B to C. And the Crown's case was that C had provided the drugs to B, and it's as very simple as that. The prosecutor would be under a duty to make sure that nothing inconsistent with that is in the intercept was put forward in the trial, of course, provided that the other evidence supported one view as opposed to the other. In other words, the duty not to mislead. Lawful authority to carry out an intercept, and as you'll see, as we go through the legislation after we've looked at the authorities which are coming up next, lawful authority to carry out an intercept is only if a warrant has been issued under ICO. In relation to store communications, of course, such as voice messages, text, other messages, and emails, there has been a targeted equipment interference warrant, which is the second part of the warrants available to the judge to grant. So in other words, a warrant under ICO, which we'll come to after Quinn has been through the authorities, for an intercept, or a targeted equipment interference warrant where you can order access to particular items that store, like phones, computers. But also under this act, an exception where in the exercise of any statutory power, so a search and seizure warrant under the Proceeds of Crime Act, or a court order made for the purposes of disclosure, for instance, perhaps in the course of civil proceedings, those would be exceptions that would allow for an intercept of the kind that the law would otherwise bar. Now, against that backdrop, I'm going to hand over to Quinn, who's going to talk about three cases which are from England and Wales in the Court of Appeal, but relevant to the new legislation that we have. And it gives you a flavour of the kind of things that we may be facing in the months and years ahead.
Great. Thank you, Andrew. Good afternoon, everybody. Well, the authorities surrounding this legislation in England and Wales have a common theme and mainly focus on the interpretation of the word interception as defined by Section 3 of ICO, which is Section 4 of the Investigatory Powers Act of 2016. And this has led to a number of challenges to the evidential use of recorded communications by the prosecution in cases whereby the defence has sought to argue that the incriminating material was intercepted and is therefore inadmissible by virtue of Section 44 of ICO, which we've just looked at. Starting with the case of Hardy, which is a 2003 case, the appellants in that case, as father and son, were involved in their family business of supplying quantities of cannabis by bringing it from the mainland of Europe to the United Kingdom. And using a false name, they rather, one might think, rather bravely placed an advertisement seeking a lorry driver for continental work. And unfortunately for the Hardys, this advertisement came to the attention of officers who'd been looking into the family activities, and they arranged for 2 undercover officers to apply for the advertised post. Each officer was equipped for the meetings with a covert recording device, which recorded meetings face-to-face, and of course, meetings or discussions that they had had over the telephone with the Hardys. Conversations recorded included the Hardys asking them, the applicants to this advertisement and the undercover officers, to apply or to smuggle substantial amounts of cannabis from Holland and bring it back into the United Kingdom. And this resulted in one of the officers travelling to Holland and meeting Hardy Jr. and collecting a lorry load of cannabis and returning with it to London. The police swooped at the warehouse where Hardy was waiting as the lorry arrived. And at court, the defence counsel requested the disclosure of the authorities under which the surveillance had been carried out, including, if they existed, authorities relating to the tape recording of the telephone calls between the undercover officers and Mr. Hardy. Well, the defence contended that unless they saw the documents, they could not investigate whether the surveillance was lawful. At that time, the governing statute was the Regulation of Investigatory Powers Act 2000, otherwise known as RIPA, and which is still in force today. And although not identical to the provisions in the Interception of Communications Ordinance, ICO, very similar. Well, the bare and redacted authorities for the surveillance were disclosed to the defence at trial. These were authorities obtained from senior police officers for the purposes of surveillance and not interception. The defence contended that the authorities were not lawful for the purposes of tape recordings and not in conformity with RIPA. An abuse of process argument was launched by the defence. The judge rejected it, and the evidence of the recordings remained admissible. Well, following the judge's ruling, the 2 Hardys, realising at trial that it would be hopeless, changed their pleas to guilty, and then they both appealed on the basis that the trial judge should have found an abuse of process and stopped the trial. Mr. Justice Hughes, as he then was before finishing his career as a judge of the Supreme Court and Privy Councillor, gave judgment dismissing the appeal. He rejected the abuse argument on the basis that the trial process was well equipped to deal with any unfairness resulting from the tape recordings, for example, by just excluding that particular evidence. Of course, Mr. Hardy was caught receiving the load when the police swooped upon its arrival, and that evidence, of course, would have been admissible. Justice Hughes then turned to the question of RIPA and the appellant's submission that what was done by the undercover officers amounted to an interception within the meaning of the Act, very similar to the definition contained within Section 3 of ICO. And in particular, as with all of these cases, as we'll see, the court considered the words while being transmitted, which is part, of course, of the definition. The court found that what had taken place was a taping of the calls and not a case of telephone tapping. In the circumstances, it was not interception and therefore did not require an authorization under RIPA for the interception of communications, and the judge was quite right to admit the evidence. That deals with the first of the 3 cases. Turning to the second, which is a 2004 case, again, Mr. Justice Hughes, as he then was, the case of the Crown against E, and this was another conspiracy to supply drugs. The police had secreted on this occasion a listening device into the appellant's car. And at a preparatory hearing, the trial judge ruled that the recordings were admissible as evidence to be used by the prosecution in that trial. The defendant appealed the decision to establish before the trial whether the ruling was correct or not. The appeal raised questions of the construction of RIPA, as we had seen in the previous case, and the recordings captured conversations. So these are the recordings from the device in the car, captured conversations with others in the car, and importantly, words spoken by the accused when in the car and using his mobile telephone. The appellant sought to argue that what occurred was an interception of the calls that he had made while he was in the car, and that they were either in interception authorized by warrant by the Secretary of State, in this case here, that of course would be a judge under ICO, or if not, they constituted an offence of unlawful interception contrary to the same act and committed by the police officers. And in any event, the evidence of the calls was inadmissible by virtue of Section 17 RIPA, which is very similar to Section 44 of ICO that we've looked at moments ago. Mr. Justice Hughes gave the judgment of the court. The court accepted the argument that if what had happened amounted to an interception, then the evidence of the content of any of the telephone calls is rendered inadmissible by Section 17, Section 44 of ICO. And the question for the court was whether the recordings at the time the appellant was on the telephone were in fact interceptions as defined by Section 3 of ICO. The court took the view that the natural meaning of the expression interception denotes some interference or abstraction of the signal, and the recording of the person's voice independently of that fact that at the time he is using the telephone does not become an interception, simply because what he says goes not into the record, not only into the recorder, but by a separate process is transmitted through the telecommunications system. So it wasn't an interception, and again, the judge was correct to allow the evidence in favour of the prosecution for the purposes of the trial. We turn to a final and much more recent case where the court had to grapple with the changes in technology, as we all have to do in these days. And this case, the case of R and A and others, a 2021 case, dealt with the question of interception in respect of EncroChat devices. This again was an investigation into the substantial supply of drugs, involving an investigation by the French and Dutch authorities who had obtained evidence of EncroChat material. The case engaged the investigation of Powers Act 2016, from which many sections of ICO have been taken. And for those of you who don't know what EncroChat is, it was a system whereby specific handsets could communicate with one another using encrypted code that could only be deciphered by those particular handsets. And the devices were effectively marketed as unhackable and impossible to intercept because of the encoding. Criminal gangs throughout Europe and the US were brazen in their use of these devices, going, as I understand it, so far as taking photographs of loads of drugs in order to advertise and promote them to sell, safe in the knowledge they thought that they could not be intercepted, and to a certain extent they were right. But the issue and appeal was whether the evidence obtained from the mobile EncroChat system could be admitted in evidence in criminal proceedings, or was it excluded by the equivalent of Section 44 ICO that we've seen. Again, the main question was whether the communications were intercepted at the time that they were being transmitted, or, as the judge found at first instance, whether they had been recovered from storage and therefore admissible under a targeted equipment interference warrant sanctioned by the Act, which you can find in Section 9 of ICO. Well, the material had been obtained by the Dutch and French investigation team by interfering with the EncroChat communication system. It was then supplied to the United Kingdom authorities. The servers for the EncroChat were situated in France. And what the French authorities managed to do rather cleverly was to discover a way to send an implant to all EncroChat devices throughout the entire world under cover of an apparent update, much like the updates that we get on our mobile telephones from time to time. Well, that implant caused every device to transmit to the French police all the data held on them that had not been erased. And this was called the stage 1 process. And all of that information, which was usually obtaining messages held for the last 7 days, was obtained by the French police. It didn't end there, though, because there was a stage 2 process which collected messages created after stage 1. And the way in which that was done was that the owner would compose a message on the device for an identified contact, and this would be held for a short time in the memory of the handset. Thereafter, the sender would instruct the device to send the message, whereby the application on the phone would ensure the encryption, following which it would be sent to the antenna for it to be transmitted out of the device to the EncroChat server. Once sent, it would be decrypted on the recorded device and then held on the receiver's device at the other end. So the French police were able to retrieve the information stored on every EncroChat device in the world. Indeed, it would have been impossible to obtain the message while it was being transmitted, because as widely advertised by EncroChat, it was impossible as it was encrypted. So effectively what they were doing was obtaining the message shortly before it was sent while it was stored in the sender's device, and also obtaining it from the receiver's device once it was stored in their handset, but not intercepting it as it was being transmitted. Well, the question for the court was whether the communications fell within section 4.4a or 4.4b of IPA, Investigatory Powers Act 2016, those same sections that have been found in sections 3.4a and 3.4b of ICO. And for anything to be classed as an interception under that definition, it has to be, again, the same words come up again, in the course of transmission. Therefore, the critical issue was the construction of section 3.4 of ICO, or 4.4 of IPA. And on this point, the court found as follows: we do not accept that this issue requires a minute examination of the inner workings of every system in every case. The statutory scheme must work, whatever the technical features of the system in question, and the words used are ordinary English words, transmission and stored. The task for the court, as the judge correctly said, is to understand the system and then to decide whether, as a matter of ordinary language, the communication was transmitted or stored at the time of extraction. If the former, it is inadmissible by virtue of section 44 of ICO. If it's the latter, it is admissible, provided the appropriate warrant was in place. And in so finding, the court dismissed the appeal. So that concludes the 3 cases, and I hope gives you an idea of the sort of issues that arise in litigation, and we'll have to wait to see whether those issues arise here in the Turks and Caicos Islands over the coming years.
Thank you, Quinn. What is quite interesting, I think, as a takeaway from those 3 cases, is that the English Court of Appeal seem to be looking at ways to work out what it is that Parliament had intended, and try to find ways that balance that intention with the reality of life. I humbly suggest that the whole basis for this complex set of sections within the Ordinance is based on a very old principle, and that is that when I have a telephone conversation with somebody, it's my telephone conversation, it's private, and really I should be entitled to speak freely on the telephone and not worry about it. And of course, that means it not being admitted in court, but it doesn't mean to say that it isn't going to be gathered as part of an intelligence gathering exercise, because it really rather appears, doesn't it, that the courts seem to be saying, if it isn't in the course of transmission, then it can be utilized in litigation. Anyway, against that backdrop, let me move through the remaining parts of the Ordinance. We've reached part 3, and let me just quickly summarize. Part 1, sections 1 to 6, just simply set out the definitions. Part 2, sections 7 to 9, the prohibitions, the offences. And here we are into part 3, which covers sections 10 to 48 of our 78 section Ordinance, which itself is divided into 5 chapters. And this is where the provision is for lawful interceptions. We begin here with a statement that the Ordinance sets out the circumstances in which an authorized person may be granted authority to carry out an interception. And that obviously means, therefore, there would not be an offence being committed. The application for such a warrant can only be made by the DPP on behalf of an authorised officer, and the authorised officer is defined as being the Commissioner or the Deputy Commissioner of Police, or someone acting for such persons. So that rather suggests that in the context of the Turks and Caicos Islands, it is number 1 or number 2 within the police service who are going to be involved in the decision-making to seek the advice from the DPP in order to make an application for a warrant. And there are, as you can see on the screen at the bottom, there are 3 types of warrants. One is the targeted interception warrants, that is intercepting the calls as they are taking place, which will either be for domestic purposes or as a result of a mutual assistant requests coming in from overseas. And then in the second part, targeted equipment interference warrants, which is where you get a warrant to hit a mobile telephone or a computer. The sections between 10 and 22 run in parallel with the sections that follow section 23, with the same kind of provisions necessary. A targeted interception warrant or mutual assistant warrant may authorize any activity for the interception in the course of transmission, that favorite phrase appearing again, whether within the postal service or the telecommunications system, in respect of communications that are set out in the warrant. So that rather suggests, again, that we are concentrating and focusing this complex scheme on the issue of what is being said by A to B during the course of that conversation as it is being transmitted. The mutual assistance warrant, which I've already made reference to, are provisions within the legislation that allow for foreign requests in and authorized requests to be made going out of other countries. Section 14 sets out the grounds on which warrants may be issued by a judge of the Supreme Court. And these are really important because it does rather suggest that these are going to be intelligence gathering exercises, because rather importantly, please note at the end, which is why I put it in blue, a warrant cannot be considered necessary, and you'll see necessity is what is set out before that, if the only purpose is the gathering of evidence for use in legal proceedings. And so the warrant can be applied for to prevent or detect serious crime. And I've already been through that schedule with you. It's in the interest of the economic well-being of the islands, or for giving effect to the provisions of a mutual assistance agreement. And that phrase, interests of the economic well-being of the islands, comes straight from the Investigatory Powers Act 2016, and perhaps shows the meaning and intent of the legislation, that over and above the prevention or detecting of serious crime, if there are attempts to interfere with the structure of society that will impact on the economy, then that is something which would permit a warrant. And let us consider circumstances where a foreign gang want to infiltrate or interfere with some government computer systems, by way of example, or it's intelligence that they want to interfere with the banking system. That's the kind of thing that we have in mind when dealing with the economic well-being of the islands. And of course, it only is possible, section 14(4), when it relates to acts or the intentions of persons outside the islands, hence my reference to people overseas. Now, a warrant for an intercept can last up to 6 months, so that when first granted, it will be for 6 months, unless it is cancelled earlier. If it's not renewed, it will cease to have effect. And these are important provisions. It's got to be on oath, it has to be in writing, and it will obviously have to clearly set out what it is that the authorized officer is seeking and what the basis for the application is. You will see on the screen that there are provisions for cancellation and modifications, but please note, the authorizing officer must ensure that arrangements are enforced to secure that there are proper provision in place relating to the retention and disclosure of material. You'll remember that it's an offence to knowingly or recklessly disclose material which has been obtained. And therefore it follows that the number of people who see the material, the extent of the disclosure, and the number of copies made must be kept to a bare minimum. I've highlighted this because I can see this becoming important and perhaps used frequently, and that is urgent warrants. If granted, they will only last for 72 hours. They can therefore be made orally, but they will have to be backed up by a written application within 72 hours. And then, of course, that may form the basis for a warrant that will last for up to 6 months. But this provision is an important one to assist in policing. Now, there are 2 sets of safeguards, but they're interesting because we would all expect there to be an LPP or legal privilege exception. And we would expect that any communications between lawyer and client would be accepted under the legislation. It is not. If the judge is satisfied that there are exceptional and compelling circumstances which make the interception appropriate, then he can grant a warrant that may otherwise fall to be defined as legally, professionally privileged. It raises a number of issues. It's legislation that has been taken from elsewhere, as I've already said to you. I can think of circumstances where an intercept between A and B, with B being a lawyer, may become compelling, but that would fall, in my view, within the traditional common law features of the crime exception to legal professional privilege. So although it provides for a codified approach to the exception to legal professional privilege, I think it probably amounts to no more than if it can be shown that there is crime afoot, such as to persuade the judge that it is exceptional and compelling, that then the interception warrant may be granted. I spent a little time on that because I think it is quite important for us all to reflect on the meaning of that. Section 17 provides for similar safeguards in respect of confidential journalistic material, or to identify or confirm a journalistic source. That's something which I chose not to spend time on, which you'll find within the legislation is set out. And it may be something of a discussion and a debate for another time. Now, I said that there are two parts to it. We have now turned to this part, chapter 2, equipment interference. It's the same processes and procedures as for an interception warrant. Interference with equipment being systems, data, or data that identifies people or events, and an interference warrant can authorize the interference. I'm sorry about that typo. I'll change it before we send it out. With any equipment for the purpose of obtaining communications data. And that means monitoring, observing, listening, recording in relation to stored communications. So that's going to be the WhatsApp messages, it's going to be the Instagrams, it's going to be the TikToks, it's going to be the oral message left on WhatsApp, or the voicemail message. It's things like that. Now, section 36 lists issues. It's quite an interesting subsection because it's a table of the kind of issues that may arise. It's the phone of Quinn Hawkins, and the reason then why I want it is because, and it sets out sets of circumstances that may lead up to the application for a warrant, and then in the adjoining column it sets out the kind of material that is necessary in order to be able to pursue an equipment interference warrant. Now, under section 35, a judge who grants a warrant is empowered to seek an update. So I suppose if I was to describe it as the judge's monitoring of the warrant, that would be a reasonable way of looking at this. And in monitoring the warrant, the judge can ask for the police, the authorized officer, to come back to explain what is going on. And you'll note that if the updates are not given as requested or ordered by the judge, the warrant can be cancelled. Note, just as a side wind, that if there is an urgent warrant application, the judge can't seek an update on that, but that's logical, isn't it? Because it's a 72-hour warrant which needs to be followed up in writing in any event. Postal articles. There's this rather interesting provision about what to do with the post, because of course, if you're allowed to intercept the post and you open it up and what's inside are some rather rotten or becoming rotten tomatoes, what are you going to do with them? According to the legislation, if it's perishable, having due regard to the interests of the person concerned, which obviously is the intended recipient, you might be able to dispose of them. But otherwise, you should retain it, if not disposed of. And if there are no criminal civil proceedings being instituted, then the postal package and its content should see its way to its destination. Disclosure orders. Under the legislation, there is provision to apply ex parte to the judge in chambers for a disclosure order. And that's to enable information held by a telecommunications company or a postal company of information that may help the investigation proceed. It can only be done in the interests of national security to prevent or detect crime, or again, that phrase, in the economic well-being of the islands. But it is a power of the judge on the application of the DPP to allow speedy access to material that is otherwise protected. Of course, in terms of passwording or secure keys, getting those is going to be the difficulty, but at least the court has the power to order, and then what follows is whether there'll be compliance. But if you tip off somebody that there is a disclosure order in the offing, then you are at risk of a fine of $20,000 or up to a year imprisonment. Fortunately, on this occasion, you will only have to appear before the magistrate and not on indictment. I add that if you are seeking advice from an attorney in relation to proceedings as a result of receiving a disclosure order, that is not a tipping off. What is communications data? Well, this is part of the definitions within the legislation that we thought was important just to highlight for you today. Communications data is what the telecommunications operator would hold, records of calls, cell points, how the system operates. That is entity data. And events data is information, for instance, about the contract between the operator and the entity. An entity, by the way, is defined as being a person or a company. And that may assist in formalizing the process by which telecommunications companies will hand over that list of telephone calls that were made or received and the cell points from which they were made or received. Now, under the legislation, the governor has powers. If the commissioner or the deputy commissioner applies under section 56, and the governor considers that it is necessary for a purpose concerned with the interests of national security or preventing or investigating crime, and that it's necessary for the authorized officer to obtain data for a specific investigation or operation, and that it's proportionate to the aim of the inquiry, the governor may make an order. And this is an interesting mix between the role of the courts in this legislation and the role of the governor in terms of urgently granting an authorized officer access to communications data. It's going to be interesting to see how that plays out. The commissioner or the deputy commissioner are also granted authority to engage in authorized conduct, and that is obtaining communications data for themselves from any person or telecommunications system, or asking any person who the officer believes is or may be in possession of the communications data to disclose it. This is the process I suggest you all by which the police, acting urgently, seeking to understand who owns a particular piece of telecommunications equipment, or where that particular piece of telecommunications equipment may be situated. This is to deal with that so that it can be done urgently in the national interest, in the interests of national security, and of course for the prevention of crime. Last slide. The ordinance provides that the governor can declare particular items of data gathering or transmitting material objects that are used for interception of communications to be listed and therefore banned. And obviously, by this legislation, it is now unlawful to manufacture, assemble, possess, sell, purchase, or advertise any equipment listed for sale, or I don't suppose they're going to be made here, but to bring them in for the purpose of selling, unless there's an exception order in place. I don't suppose there are going to be many of those. Plainly, as a fallback position, the ordinance provides for the forfeiture of listed equipment that may be seized from a person who is convicted of an offence. Now, that was, ladies and gentlemen, a whistle-stop tour through this rather complex piece of legislation. I think what's so interesting about it is that the three cases from England really are it in terms of importance as to how the legislation has been reviewed in England and Wales. It is so full of complex provisions that I worry, if I may say this, as to how effective it is going to be in the Turks and Caicos Islands. I rather hope it can be used, but it has got complexity in it. It's going to need the judges to consider with care applications brought by the DPP, who is going to have to consider with care the position of the officers who seek the intercept warrants. And of course, the officers are going to have the equipment and the ability and the training to be able to go through with the provisions of the legislation, which then leads me to part 7 and the final part, where Parliament has asked for there to be reports. It has made provisions to protect the authorised officers who behave properly from any comeback, and obviously has made some provision for costs of implementing the scheme. I hope that's been helpful. It's certainly a lot to digest and think about, but it's going to be interesting to see how this plays out in the months ahead. Thank you for your time.
Thank you very much for that, Mr. Mitchell and Mr. Hawkins. We can take a couple questions if any of you have any questions at the moment. You can electronically raise your hand, or we can get to them at the end of the session, or you can submit your questions into the chat. I know it was a lot of information, and I can promise you that Mr. Mitchell's and Mr. Hawkins' presentation will be circulated, so you will have the opportunity to digest and to apply it then. Okay. So if we don't have any other questions, thank you, Mr. Mitchell and Mr. Hawkins, for sharing with us. Please allow me at this. Pardon me?
I said it was our pleasure.
Thank you. Very kind.
Thank you very much. Thank you.
Okay, we have another session coming up now. So, but at this time, please allow me to specifically acknowledge Chief Justice Winder of the Commonwealth of the Bahamas, and who also sits on our Court of Appeal. He's with us today. I see that Deputy Commissioner of Police, Mr. Rodney Adams, is with us, and Resident Magistrate Salva Gardner has joined us. So welcome. For the benefit of those of us who joined us a little later, our next presentation will be on the anti-gang ordinance here in the TCI. And Mr. Rajiv Prasad will be exploring with us this anti-gang ordinance. Mr. Prasad, just to recap, is the head of Alum Chambers in Trinidad and Tobago, and he has advised and represented persons charged with offences under the Trinidad and Tobago iteration of the Anti-Gang Act. So, Mr. Prasad, I now hand over to you. And thank you for joining us.
Thank you very much, Ms. Difu. Allow me first to acknowledge and express my gratitude to the Judicial Education Institute for inviting me to make this presentation, and to acknowledge members of the judiciary, higher and lower judiciary, and all distinguished guests. Mr. Mitchell put it correctly, Friday afternoon while a Brazil match is going on, and then I have the added honor of coming after him. So I'm going to have to pull all the stops out to make my presentation. What I propose to do, ladies and gentlemen, is try to make my presentation stick to about 40 minutes. I'm going to try my best to take you through some of the provisions of the new anti-gang ordinance, and by so doing, leave some time for questions, both in relation to Mr. Mitchell and my presentation, if in fact there are any. So without further ado, allow me to indicate that the question of gangs in the region, the Caribbean region, has really emerged as a very topical issue over the last decade and a half. And the emergence of these gang activities have precipitated the need by regional governments to resort to what may be described as extreme legislative interventions in order to deal with this problem. So what I will hope to do is, after I make the presentation, I intend to circulate it or send it to the JEI by tomorrow morning with the materials, cases, and other pieces of legislation. One of the things I was able to find was an interesting article that spoke to the question of gang activities, both in Trinidad and the region as a whole. What I noticed when preparing this presentation was that the passage of the ordinance in the Turks and Caicos Islands earlier this year, and the proclamation by Legal Notice 73 of 2022, was just one of a chain of pieces of legislation that seem to be embracing the region on the gang issue. Jamaica, which, and I don't think it's unfair to say that both Jamaica and Trinidad have really, outstanding gang issues, where large percentages of the murders coming both out of Trinidad and Jamaica are gang attributed. So in Jamaica, as far back as 2014, they introduced the Criminal Justice Suppression of Criminal Organizations Act. Introduced in 2014, amended in 2021, and the legislation really focuses on criminal organization. Gang violence in Jamaica, for instance, accounts for 80% of the murders, according to one writer. In Trinidad and Tobago, the anti-gang legislation was introduced in 2011, amended in 2018, and then 2021. St. Kitts and Nevis, small island. I was very pleasantly surprised when I saw that they had a gang problem, but legislation was introduced back in 2011. Their Gang Prohibition and Prevention Act. St. Lucia also has an anti-gang act since 2014, and Bahamas amended its penal code in 2014 to allow for gang-related offenses, and as recently as April of this year, is reviewing regional precedents to determine whether there is need for specific standalone legislation to deal with gangs. Now, the ordinance as introduced in the Turks and Caicos Island can be divided really into 5 parts. The short title of the ordinance is to make provision for the maintenance of public safety and order through discouraging membership of criminal gangs and the suppression of criminal gang activity and for connected purposes. Now, we have to keep in mind that the legislation, the ordinance that is being introduced here is criminalizing activities that previously was not considered criminal acts. So when you look at the legislation now and what it creates, members of the public have to be informed and have to be brought up to speed to realize that what before the introduction of this ordinance was permissible and acceptable is no longer considered acceptable. And persons, particularly when we consider their offenses like harboring a member of a gang, a lot of innocent persons are going to get caught up in this legislation because the provisions, if not used to educate the members of the public, are so far-reaching that they have the potential to have very unfair effects. So let's talk about the ordinance. The ordinance is divided into 5 parts. The first part is the preliminary section, and that section deals with the short title, as one would imagine, an interpretation section, and a section that deals with the concept of evidence in relation to a gang, a very important section. Part 2 of the ordinance creates a number of statutory provisions giving rise to a range of new offenses. And that is what is one of the outstanding features of this ordinance, is that we are creating new offenses for the members of the public. Part 3 of the ordinance deals with the power of the police and police officers and specifies the police powers of entry, search, and seizure, as well as the detention of persons. And this is a very interesting area that I will develop on in a little while. Part 4 of the legislation deals with the forfeiture of property of persons convicted of offenses under this ordinance. And Part 5, not as long as complicated as the previous ordinance that Mr. Mitchell dealt with, Part 5 has a miscellaneous section, but has something which we tend to describe as what we call a sunset clause, where this legislation is only to be enforced for 36 months from the date of its introduction. That is something to keep in mind. Of course, there is a provision that allows that if the legislation needs to be extended, it can be extended by cabinet. Finally, the legislation has 2 schedules at the end of the ordinance. The first schedule deals with a list of serious offenses. Many of the offenses, there are no surprise, whereas Schedule 2 provides forms that allows for an application for a detention order in relation to persons, as well as a notification form that deals with forfeiture if somebody has his or her items seized in the course of some arrest or investigation to gang activities, and that person is the owner, he or she is entitled to file a notice. I think it's usually 2 weeks after it's gazetted, and express his or her interest in the property before an order of forfeiture is made. So broadly speaking, it's not a very long piece of legislation. It is very focused and it deals with specific areas. But the areas that it does focus on really tends to create new offenses and give powers that are very, one may describe as draconian in nature. Hence the correlation with the question of sunset clauses and this legislation not being what may be described as permanent legislation. So I have opted to identify some key provisions. As I've indicated, I have going to comply with a 40-minute timeline so I can leave some room for questions. So I'm going to just pick on a few key provisions and just make a few observations. Now, the ordinance seeks to make it an offense to be a member of a gang, to be in possession of a bulletproof vest, to participate in or contribute to the activities of a gang, to support or invite support for a gang, or to harbor or conceal gang members. And this is just a range, but we need to look a little closer to what exactly is being contemplated by the ordinance. Section 4 deals with gang membership, and what it says, a person who is a gang leader or is a gang member or performs an act as a condition for membership in a gang, or, this is interesting, professes to be a gang leader or a gang member in order to gain some benefit for himself, to intimidate some person, or to promote a gang, commits an offense. So, you know, that's a very broad offense. And it basically, when one looks at the interpretation clause, the definition of a gang means a combination of two or more persons, whether formally or informally organized, who engage in gang-related activity. Gang-related activity is defined by the ordinance as planned, ongoing, continuous, or repeated participation or involvement in any serious offense. And serious offenses is listed in the schedule, Schedule 1. So I'm not going to hesitate to say this is broadly drafted legislation, and this legislation has the potential to be very wide. It may very well be that that's the intention of the drafters. The legislation in the Turks and Caicos Islands is not really different from many of the other Caribbean islands, but there is a mindset that the legislation needs to be drafted in a very broad manner. Another offense, so it's not only impermissible or now illegal for a person to be a leader of a gang or a member of a gang or to profess to be a gang leader or a gang member, you know, as I say, to intimidate another person. But Section 5 provides a person who coerces, encourages, entices, aids, and abets another person to be a gang leader or gang member commits an offense and is liable on conviction on indictment to 25 years imprisonment. So that is now an offense. If you aid or you coerce and encourage someone to become a gang member or a gang leader. One of the key provisions in the ordinance is an acknowledgement that in the world of gang activity, one of the pressing problems is the question of retaliation. And not surprisingly, Section 6 of the ordinance provides that a person shall not intentionally take any retaliatory action against another person or any of that person's relatives, friends, associates, or property on account that the other person refused to become a member of a gang or a gang leader, ceases to be a gang leader or gang member, giving information to law enforcement or intelligence agency, assisting in the investigation of a gang. So what is interesting here is that there is no legislative intervention that, to the extent that there exists, gangs in a particular territory, that it is outlawing at this point any attempt by any member of a gang or any person, actually, because it's broader than that. You don't have to be a member of a gang for this retaliation clause applied. Any person who takes any action that may be deemed retaliatory against relatives, friends, etc. And this is, in my view, a good provision because it seeks to outlaw retaliatory action by any person. Equally, we have section 7 of the ordinance that says, well, a person who knowingly, and again, we have to take into account that these offenses are very much requiring mens rea, and that is exceptionally important when these cases actually come to court. What is required to prove, and the fact that mens rea is going to be very important some will argue, mitigate the harshness of the broad drafting. But section 7 says a person who knowingly counsels, gives instruction or guidance to, finances in any manner, or otherwise provides support to a gang leader, gang member, or gang in furtherance of his or its participation in the commission of gang-related activity, commits an offense on indictment for a term of 25 years. So again, counseling, even though that is the rubric used in the side note in terms of the section, it's much broader than counseling, and it's, giving instructions, financing. So if you think about it, the way this provision, section 7, is crafted, it is very broad, very all-embracive, and one can understand why it is drafted in that way to basically ensure that any culture within any society involving being a member of a gang, encouraging someone, this legislation has a zero tolerance policy, and anything from financing, from counseling, giving instructions, guidance, it's now illegal, unlawful, and the person stands, if convicted, a maximum of 25 years imprisonment. Now, these are just some of the more important provisions in terms of the offenses, but when one looks at it, it is clear they are draconian in nature. Many will argue that they are necessary depending on the situation, and there are other offenses which include things like preventing a gang member from leaving a gang. So if you find a circumstance where someone is trying to leave a gang and persons are discouraging him, and those persons could be charged. Possession of and this is quite interesting because I could tell you, like in Trinidad, many of the murders, you will hear evidence coming out in the trial that persons had a bulletproof vest or a firearm or ammunition, and they would give it to other persons to hold. And when the time came to go and commit the offense, other persons would provide the materials for the offense to be carried out. So here you have express provisions seeking to deal with bulletproof vests and firearm and ammunition or prohibited weapons for the benefit of a gang. Now, some may argue that there is enough legislation for possession of a firearm, possession of ammunition. Is this absolutely necessary? On the other hand, it will be argued, well, in the scheme of this legislation is seeking to deal with a specific problem, it may be appropriate and proportionate in all these circumstances. Offenses also includes harboring gang members, concealing a gang member, recruiting a gang member, tipping off. So I think what is important is that when one comes to look at the ordinance, we appreciate that this ordinance is creating what I may describe as a superstructure within which prosecuting authorities can try to rid the jurisdiction of gang activities, gangs, and all matters relating. And I suppose if it works well, it can be a very important tool in trying to solve the problem. The question, of course, is it going to work well? And one of the big issues, and I wanted to look at section 3 of the ordinance, is the question of evidence in relation to a gang. Now, traditionally, it has always been said, well, in order to show that someone is part of a gang or to show the existence of a gang, you'd look at whether there's a name, insignia, flag. I think we all have heard of the Bloods and the Crips and the different Hells Angels and different gangs that were known throughout the United States over the years, whether they have a flag, a secret signal, a code, a belief or structure. And one of the interesting, pieces of drafting in relation to this ordinance is that section 3 of the ordinance says this: for the purpose of this ordinance, it shall not be necessary to show that a particular gang possesses, acknowledges, or even is known by a common name, an insignia, a flag, means of recognitions, creed, belief, structure, leadership, command structure, concentration or specialty, membership of age, operation. So what did section 3 of the ordinance say? You don't need to do that. But what the legislation, the way the provision is drafted, is saying you don't need to prove those things, but it goes on to say when the gang existence can be demonstrated by other admissible evidence. And I want to stress other admissible evidence, but evidence which reasonably shows or demonstrates the existence of or membership in a gang shall be admissible in an action or proceedings brought under the ordinance, including. So my understanding of this provision, which is, a very long and very complex, it's drafted in a way that it really makes you look at the provision in detail, is that what the drafters are saying, to prove the existence of a gang, you don't actually have to go with these traditional ways if the gang's existence can be otherwise demonstrated by other admissible evidence. And what they describe as other admissible evidence includes things, and is specified in section 3, whether the person has admitted that he's a gang leader or gang member. Well, to me, that's saying the same thing as he confesses. So if the person says, well, yes, I'm the leader of a gang, or I'm a member of a gang, and he's admitting something that implicates him in the offense of being a member of a gang, well, yes, of course that will be admissible. There's B, evidence that a person is or has associated or been involved in a gang with an intent to facilitate the commission of gang-related activity or to promote further or assist. Now, that evidence of a person has been associated will have to be seen. How is the prosecution going to get that evidence? And the question of gathering evidence to support these charges is going to be a live issue in the implementation of the act. Now, it's one thing to stipulate, as section 3 does, the types of admissible evidence that could be used to establish the existence of a gang, but getting it is going to be another issue. So for instance, C, evidence of criminal activity by the person that indicates a link or involvement with the gang. Now, of course, you can get witnesses who can come and give evidence of the person's link or involvement in the gang. Are those witnesses going to be persons who were in the gang? Are they going to be police officers who made, through surveillance, observations, etc.? those are things that the courts are going to have to grapple with. Evidence that the person knowingly concealed or shared in the proceeds of gang-related activity. So if it could be shown that an individual has received monies, has received the benefits, vehicle, or other forms of monetary benefit that is linked directly to the commission of acts by a gang, then such evidence may be admissible. But again, it's going to come down to how the persons who are gathering the evidence are able to put that evidence together. So essentially, at this point, it is clear that the ordinance is creating a regime of offenses that requires persons who are or may be involved in gangs to come to an understanding that such things are now unlawful. They may have membership in a gang. And remember what the definition of gang is. And I mean, again, it's gang means a combination of two or more persons, whether formally or informally organized, who engage in gang-related activity. That, remember, is the background to how this ordinance is drafted. So if you are more than one person informally or formally organized involved in gang-related activity, which really refers to any serious offense, and serious offense, as I mentioned earlier, is to be found in the second schedule, sorry, the first schedule. The question of distinguishing between aiding and abetting in an offense, because you have everything from murder, manslaughter, kidnapping, offenses under Integrity Commission proceeds a crime. It raises very interesting questions of how does one distinguish between aiding and abetting or being involved in the commission of the actual offense, and then the creation now of whether or not by merely doing that I'm part of a gang. And so it just seems to me that you are going to need something beyond normal evidence to bring it into the realm of saying this is a gang-related offense. Now, it's one thing to create ordinance or create new offenses, which the Act clearly does. The second part is we now have to consider that the police have to be given powers to deal with supporting and investigating the offenses under the Act. So part 3, as I think I had mentioned, deals with the police powers to arrest, search, seizure, and detain. So Section 14 of the ordinance deals with that, and it says that a police officer, and this is a constable or at that level, may arrest without a warrant a person whom he has reasonable cause to believe is a gang leader or gang member, or who he has reasonable cause to believe has committed an offense under this Act. Well, of course, if the person is a gang leader or a gang member, he's committed an offense. Now, the police also have the powers to issue a warrant to a police officer, authorizing the police officer to enter and search a dwelling house if the magistrate is satisfied or by evidence or that there's reasonable ground for believing that they may be found in the dwelling house a gang leader, a gang member, or a person from whom the magistrate has reasonable cause has committed the offense. It just means now that judicial officers now, in having to issue these warrants, are going to have to pay particular attention to what is the evidence on the application for the warrant that justifies the issuing of a warrant under this section. The police officer under subsection 3 of section 14 may enter without a warrant and search a place or premises not used as a dwelling house, including building, ship, vessel, carriage, box, or receptacle, if he has reasonable cause to believe that a gang leader, gang member, or a person whom he has reasonable cause to believe has committed an offense under the ordinance, may be found in that place or premises. So again, you can go to a magistrate, or you may not need to actually have a warrant in particular circumstances. The Act also allows powers of detention. And not surprisingly, Section 15 outlines the process to detain persons under this ordinance. Now, some key pointers that you need to keep in mind is that an officer, constable, I imagine, can detain a person up to 72 hours. There is an obligation, of course, after the 72 hours, if the police wish to continue to detain the individual, the commissioner of police has to get involved and justify a further detention of a further 72 hours. If after the first 72 hours by the constable and then the further 72 hours by the commissioner of police, there is need to continue to detain the individual without charge, a police officer, the rank of superintendent, may approach the court to grant an order of detention for up to up to 14 days in total from the arrest. Now, the ordinance places very severe obligations on the police detaining the individual to notify the individual of why he is being detained, and also to record the grounds for the detention in writing at the police station. At every stage of the detention, the ordinance provides the person seeking to justify the detention or further detention must establish reasonable grounds that are specified in the notice and in the legislation to continue to detain in order to justify the detention. So that deals with part 4. The power is also available to judicial officers to confiscate or forfeit property where somebody is convicted of an offense under the legislation. Where a person is convicted of an offense under this ordinance, the court may order that any property used for or in connection with or be obtained as a result or in connection with the commission of the offense can be forfeited to the Crown. Now, it is important to note that subsection 3, while on one hand the powers to forfeit are given in the ordinance, subsection 3 provides a person who claims to be the owner or to have an interest in the property shall file a notification of interest within 2 weeks. And that form is found at Schedule 2, and it's a second form, 2 weeks of the date of the publication of the willingness to forfeit. So again, when one looks at the provisions, we create offenses, we define gangs, we give the police powers to arrest and detain, and we make sure that we can forfeit property derived from gang activity. The legislation, the ordinance, appears on the face of it to be dealing with what may be described as the key areas that need to be approached when dealing with gangs. Now, I am going to move on to what have been described as some of the experiences. There is really not much cases on the questions of gang activities in the region. I have been able to identify a few, but even though the legislation has been around in jurisdictions like Trinidad and St. Lucia, there has not been a plethora of cases. In Trinidad in particular, I'll give you the experience, which is a little embarrassing to some extent, but I will. Our legislation in 2011, anti-gang legislation, was passed in August of 2011, and the police in their wisdom decided to go and pick up about 100 persons believed to be gang members and gang leaders. they did so within a week to 10 days of the legislation passed. And I think we were actually in a state of emergency in those days. And what the police regretfully realized is that having arrested and detained so many persons, they really were in a difficulty to put evidence to support their charges because, you know, the simple point is, before the legislation came in, the conduct that was being held unlawful was not unlawful. So the police officers, although they had all this information that related to times before the legislation came in, could not be admissible because at that time, the activities were not unlawful. And so the police officers detained persons, kept them for particularly long periods. Charges were initiated under the anti-gang legislation, and the Director of Public Prosecutions had to intervene and drop the great majority of cases, which led to a significant number of persons bringing malicious prosecution, false imprisonment cases. And, you know, in August of 2011, I think by August, September, October, by October, November, the DPP had to drop the majority of cases. And I'm just going to mention a few cases where significant damages were given by the court in Trinidad for unlawful detention, false imprisonment, etc. So in a case called Joel Walker and the Attorney General, the claimant was charged under the Anti-Gang Act and detained for approximately 56 days. He was awarded 220,000 TT dollars compensatory damages, including aggravated damages. Chap called Darrell Bishop sued the Attorney General, where during the state of emergency, 20 police officers entered the claimant's business place, arrested, and then charged him with being a gang member. The defendant claimed he was suspected of carrying out narcotics and firearm offenses and detained him for 45 days. He was awarded 250,000 in general damages, malicious prosecution, and other forms of exemplary damages. Michael Douglas versus the Attorney General, where during the state of emergency, officers entered the claimant's home around midnight without a warrant, arrested him for being suspected member of the Beatam gang, that's an area just outside of Port of Spain. The court inferred malice because of the lack of reasonable and probable cause of the arrest. The claimant spent 41 days in custody, was awarded 200,000 in general damages and exemplary damages. So these are just, and there are many, many cases that talk about the question of the police powers to detain, the police powers to arrest. And, you know, in that particular case, I suppose the lesson to be learned is that those persons who have the responsibility of investigating and prosecuting persons under this ordinance need to be careful, need to be, I want to use the word restrained in how they approach the arrest and detention, and they must ensure that they don't find themselves in a situation where you go out because you have the legislation there to just go and arrest people and detain without evidence to gather to justify the arrest. And so what in fact this did in Trinidad and Tobago was that in 2011, even with the advent of the legislation, there was just a reluctance on the police after they had gone through this exercise of arresting and detaining so many people, and then have to find themselves in the position that the Director of Public Prosecutions had no choice but to drop the great majority of cases, because when they came down to sit down and analyze what they thought was admissible evidence, what they thought was evidence of gang activity, because just because the police know you're in a gang or you associate, etc., your conduct predating the advent of the ordinance, you know, is not going to be particularly helpful. You have to use material evidence and circumstances that occur after it becomes unlawful to be a gang member. So I just start with that observation. There was one other case from the Court of Appeal of Trinidad and Tobago, which basically had to do with one of these malicious prosecution cases. And Mr. Justice of Appeal Barrow, and all these cases I will attach when I send the presentation, made some interesting comments, because the million-dollar question with these gang cases is how you're going to present evidence to back up a lot of what you are alleging as part of your case. And Mr. Justice Barrow, in reviewing one of the malicious prosecution cases, made this comment at page 10. It's in the case of the Attorney General and Stewart. And as I say, it will be provided in the package that I sent. He says, it is readily apparent from these provisions, referring to the anti-gang legislation, that proving gang membership in a court of law is no slam dunk. It requires a careful compilation of the evidence showing how the gang is organized, how the gang activity is perpetrated through gang members, and their respective roles in such activity. Let me point out the legislation, the provision that the Ordinance provides in Section 3 about gang membership, etc., is identical to what obtains in Trinidad. Evidence at trial must be carefully led to show the nexus between the gang, the members, and the activity. In a case where the gang-related activity relates to narcotics, evidence of actual sales of the narcotics is required to prove the gang-related activity. Mere surveillance without more may not suffice. It is not enough to simply observe the accused making interactions with other persons. The evidence must be that narcotics were sold by the accused to someone. This would include proof of exchange of money and the actual price paid. Undercover detection may be necessary. The best evidence would no doubt be that of a former member of a gang who has direct knowledge of its activities. Now, not going to go into all the dicta, but you can see from our Court of Appeal that in these types of matters, there is a high threshold of investigation expected. You are not, and I, one may argue it's because of the nature of the legislation, and it may be quite proper that, the quality of the evidence establish some of these issues will be, perceived as somewhat higher. I mean, every case we know in a criminal trial depends on the broad evidence overall, the overall evidence. But if you are going to establish that someone is a gang member or a leader of a gang, etc., there is going to be an expectation by the courts that you are going to come with something that is of a nature that is going to satisfy the fact-finding tribunal. Now, one other case that I wanted to just mention that will be provided dealt with a Privy Council decision, Myers and Koch coming out of Bermuda. And one of the interesting issues in that case was, and in that particular case, it was an appeal coming out of gang evidence, or evidence of gang relations. And one of the issues that the Privy Council had to grapple with is that we are all familiar with the concept of, or the principle that where a person, well, let's put it this way, it's not competent for the prosecution to adduce evidence tending to show that an accused has been guilty of criminal acts other than those covered by the indictment, for the purpose of leading the jury to the conclusion that the accused is a person likely from his criminal conduct or character to have committed the offense for which he is being tried. So simply put, it has long been the position, going back to the cases of Macon and Boardman, which are cases that have well-known Privy Council and House of Lords decision, that the prosecution just cannot simply adduce evidence to show that an accused person committed other acts or other acts of reprehensible behavior for which he's not charged, and then ask a jury to take that into account in determining whether he is guilty of whatever offense. There is a view that a lot of gang type evidence will focus on matters like this. And so it raises, a question not only for the judicial officers, but for police officers and those seeking to prosecute, that you have to keep in mind that in bringing evidence and gathering evidence, you have to be mindful of the principles in cases like Boardman and Making, that if it's just really to show propensity, that the person has a propensity to get involved or be involved in criminal activities, etc., the court, as a general rule, will not allow it. And I mean, of course, like all rules in evidence, there are exceptions, and there's the rule in Petman, and there are other rules that may allow for such evidence to be admissible. And of course, depending on what law obtains in Turks and Caicos in terms of bad character evidence, whether it has adopted the new position of gateways, etc., in the Turks and Caicos, it may not be an issue. But it is something that those persons who are gathering evidence need to have at the forefront. And the Privy Council in Myers and Cox went into the whole question about admissibility of gang evidence. They went into the question of whether a police officer can give expert evidence in relation to gang issues. And they also went into questions of motive, etc. So I'm going to commend this case to everyone participating to read to get a sense of some of the issues that tend to arise. The last case that I really wanted to just touch on, it comes from Jamaica. It's a case of Collington, Godfrey, and others. It was a High Court decision in which the Chief Justice Sykes presided, and it was a matter under the Criminal Justice Suppression of Criminal Organizations Act. Now, the first observation I want to make to you is that the Jamaican legislation is not pari materia to what we have in Turks and Caicos or in Trinidad. And the focus in their legislation is to basically outlaw criminal organizations. So their structure of their legislation is important. But what I found is that the case of Godfrey and others was particularly interesting because Chief Justice Sykes, in reviewing the case, went into a little bit about statutory interpretation and this type of legislation. And I think there is a benefit to be obtained by reading it. And also it raised, and it also dealt with the question of bad character evidence as it relates to gang evidence. So allow me to say this. There is not much case law coming out of the region. Before I came to do this presentation, I checked with one of our deputy directors of public prosecution just to see, because one would have thought, of course, that since our legislation has been around since 2011, there would have been an abundance of case law on it, but there isn't. And in fact, after the experience in 2011, where so many charges were brought and then discontinued because of the lack of evidence, there was a reluctance by the prosecuting authorities to initiate. In fact, I was confirming with one of the deputy directors that as it stands in Trinidad right now, there are essentially 3 prosecutions under the Anti-Gang Act. One deals with the, I have to say it's a notorious case involved where a gang in Trinidad has been charged with the murder of a very well-known senior counsel. That matter has recently been committed to the High Court. So it has not been set for trial, but is expected, I imagine, within the next year or two to come up. And that perhaps is going to be the first case that is going to deal frontally with legal issues and evidence arising under the Anti-Gang Act. And I can tell you that in that particular case, there is an abundance of reliance on intercept communications, etc., as part of the evidence in that case. There was one other prosecution where a chap was charged as a gang leader, but that person met his demise in the last few years, so that case fell by the side. And I'm told there's one more case that is coming up through the magisterial committal process, which has not reached the High Court, and that may take a few years. So there aren't many cases, and you can't help but notice, looking through the region, many of these cases are failing at the trial stage, and many of the cases are being thrown out because of a lack of proper evidence. So I notice it's approaching 5 o'clock, so that in a nutshell is what I really wanted to get across to members this afternoon on the anti-gang legislation. It's important, I think, that we accept and understand that it is a necessary piece of legislation. It is harsh, there's no question about it. Over the last few years, emerging criminal problems dealing with drugs, dealing with other matters, have led to pieces of legislation that tend to be very harsh, and properly so. But the question is, it's a question of how the courts are going to deal with it. But there is an onus on the prosecuting authorities, the investigative authorities, to really address their minds to what kind of evidence they are going to be able to gather, what techniques in investigation will be necessary. And of course, for counsel, those on the defense side, to really sit down and think about the types of evidence coming and to what extent they line up with fundamental principles of criminal law. And that is why, one accepts, when I started my LLB, when to say many, many years ago, we were taught there had to be a coincidence of actus reus and mens rea in order for a criminal offense. That, I think, has whittled down significantly. And, much has changed over the last few decades in how criminal matters are, created, legislated for, etc., and the proliferation of strict liability offenses, etc. So it is, we keep that in mind. But I do think, as I said earlier, when you are bringing in legislation that is really making illegal something that was not in the past an offense, there's also an obligation to educate persons, particularly where you have legislation here that is saying if you harbor somebody, if you encourage somebody to go involved, there is a need for that public education. So my clock is saying 5 o'clock in Trinidad. I am going to stop there and invite questions and comments if anybody has. Thank you.
Thank you so much, Mr. Prasad, for that. Before we get into the questions, I just want to acknowledge that our Director of Public Prosecutions has joined us. Mr. Tounier, King's Counsel, is now with us. So we thank him for joining us. So any questions, you can raise your hand electronically or submit one to the chat. Oh, I see our DPP has a question for you, Mr. Prasad. Yes, DPP.
Thank you, Aisha, for moderating so far wonderfully. I've been in the room before you started, but I was using a pseudonym, if you don't mind. but I just suddenly changed it. I was telling Andrew about it. I want to adopt the protocol you have already established, but I really need to acknowledge the presence of our acting president of our Court of Appeal, the Honorable Justice Adley, in the group. It's an honor to have him with us, and the other justices and their honors that have been with us since the beginning of the session. And again, I'm not the person delivering the task to the wonderful presentation that have been made by Andrew, Michelle Casey, and Queen Hawkins. Of course, the last one now by Mr. Prasad, very outstanding presentations within very short time. I consider what has happened this afternoon more like a roadmap, bullet points that those of us who are in prosecution and those of us who are in investigation will take into account. I don't know whether we can bring you back again, Mr. Prasad, but I think we have the privilege and the honor of having Mr. Andrew Mitchell, Casey, and Quinn still around us. And as many resources as we have locally, we will use them to really delve into the practical outworkings of these ordinances. They have been described very rightly so as complex. They are draconian in nature. And of course, we have now seen two spectrum of judicial reaction, one coming from UK in relation to interception of communication, three judicial decisions that are quite heartwarming for me. And then the other spectrum is the Trinidad one, where my colleague there had to withdraw cases and because of the judicial approach and judicial response to laws like this. It bothers me, I must say, colleagues, and that when it comes to public education, as Mr. Prasad was saying, that education should not just be restricted to the public in terms of those who are not lawyers. I think there is need for this discourse that has taken place this afternoon, and I'm so grateful for the full representation of the TCI bench to this session this afternoon. Let me make this last point, and that is relevance. In our society, the legislature will always, and I give it to them, react as politicians, react as the political directorate. They want to reflect in the laws that they pass, the feeling and the prevailing circumstances, the trauma of their people who have elected them to do something, and they react the way they have done. Provided it is not unconstitutional, provided these laws are not challenged on the basis of their unconstitutionality, and they are standing as it were. We have always received it from the bench that, listen, our job is to interpret. But I think that there is need also that while we are grappling with our weaknesses as institutions that prosecute and weaknesses as institutions that investigate, the bench also will need to be sensitive to the environment. I heard Justice, I think it's I can't remember his name now, when he was dealing with trafficking and human smuggling, that when we are not conscious of the dominant purpose of a legislation, and we stay in our ivory tower, either as prosecutors or as investigators or even as judges, we lose relevance, because whatever happens at the criminal justice system, the people we serve want us to give to implement at whatever level. And I'm grateful to you, Mr. Prasad, for what you were saying about investigation and the prosecution. It doesn't stop there. It goes up to the judiciary, up to Court of Appeal, because they are manned by human beings who are also living in an environment that have prompted very draconian laws to be rolled out. And we all should together not make the criminals look like we are fools and they can make a mess of the society, very few of them, and they terrorize the whole place. And we cannot move freely in the country that where we are in. And so it has to be a joint effort. It has to be sensitivity to what the legislatures have done throughout the region I'm talking about, not just the Turks and Caicos, and to reflect that in a very sensible, balanced, scholarly way, to also tell the public that we are not on our own. We are identifying within the context of the law what issues they are grappling with as a society. That's just the general point I want to make. Thank you very much.
Thank you, TPP. Any other questions? Yeah, raise your hand. Mr. Prasad, I had a question. You talked about, and the DPP talked about, there being some aspect of public education, so that people who don't know that they're doing wrong aren't caught in the dragnet. So I wonder if there is precedent, maybe from Trinidad or from the other Caribbean regions, of that being done, or is that just a recommendation you made because of your experience, or have you seen that implemented anywhere?
Well, there was absolutely no education in Trinidad, and I think that probably is what precipitated the problem in the first place. I can't speak to the other islands, Jamaica, for instance, but I just think that when we are creating new offenses, when we're passing ordinances or legislation that criminalize things that, hitherto was not really impermissible, it becomes all that more that people, laypersons, appreciate how things are changing. Because the truth is, majority of persons who find themselves involved in gangs come from very poor areas, come from areas where education is not the best. And it's an environment that, does not really, it's a culture, regretfully. It's a culture, and you want to get across to those persons to indicate that this can't be happening. But people live in an environment where, because of impoverishment, because of other factors, they that's what they used to. And so it's not, legislation is of course one way, but that social intervention to try to prevent those issues from coming up becomes all the more important. And that, unfortunately, just from experience, from watching these things play out in the courts. So yes.
Okay. All right. Well, thank you for that. So my next question was, I wonder if you have any views on who should take, or which institution should take the lead on implementing education for the public, but maybe it needs to be cross-institutional, because you talked about that social aspect of it. So you see.
I wonder whether the police should be thinking about putting up posters that simply explain what that position is and how serious the consequences are. But I mean, that's something which would be interesting to hear what the police have to say about it. But I mean, I take Rajiv's point. It's really important to bring home to everybody the importance of this scheme, and a poster campaign, radio adverts, interviews. Maybe that's something which the police would think about.
Good afternoon, Deputy Commissioner Adams here. Mr. Mitchell, if I was a batting man, I would have said you was peeping my notes. Thanks to all three gentlemen for the great presentations, as outlined by the DPP earlier. And certainly it's something that we are going to be working on through our community policing section and getting into the schools, educating the young people, because we know throughout the Caribbean, our young people are influenced by what they see on television, and especially in the high schools, they have this gangster mentality. So we want to start educating them and look at preventative measures and intervention measures rather than waiting until they become frequent flyers, getting involved in these activities. So thanks for that. And thanks again to all for your presentations.
Thank you.
Thank you, Deputy Commissioner. We have a comment from Sheena Mayer. She says, an observation on the last point by the Director of Public Prosecutions. The judiciary is required to be fully independent. They should interpret and apply the law without fear of repercussions and without undue influence emotionally or socially. Thank you for that, Ms. Mayor. I wonder if we have any other questions or comments. It doesn't look so. So thank you all so much for being engaged.
I think there's a hand that went up, Honorable Willie Bilayad.
Yes, thank you. Thank you. Thank you.
Oh, I apologize.
Good afternoon, all DPP and Mitchell KC, Mr. Pessoa, the presenter, and the other in the panel. I think this piece of legislation, first of all, I'm a member of Parliament and Tucson Caicos. Mr. Pessoa may not know, the rest of in the video may know. This piece of legislation was very complex. The members of Parliament who were not attorneys find it difficult to grapple with the complexity of it. And I do believe that we should take a similar approach to the one that we took when we launched the Integrity Commission. There was a lot of education campaign that went on, a lot of ads on the radio, and different public awareness campaign took place to make the public aware of this new institution and this new set of legislation that was new to us. Similar to this legislation, if we adopt a similar approach, I think we'll be in a much better place. Although the Integrity Commission was a different beast, a different set of laws, it came in for a purpose. This one is coming in also for a purpose. So it's very important that we don't leave the public behind so that innocent persons can perhaps protect themselves from being caught under the net, especially for the offense of harboring. I can see this one very, very dangerous for many if they're not aware of the consequences. Thank you.
Thank you, Honorable Balliard. I wonder if we have any others, and I apologize again for missing that hand.
I think there's one hand from
there.
somebody I can't see.
Dan Isaac.
Oh, maybe it's gone.
Okay. All right.
It was Mr. or Ms. Isaacs, but I think that, oh, that's come. Does the new changes allow us to ask businesses to preserve any important data? I don't know whether that's coming from a police officer or somebody in the private sector, but I think the answer is that if you anticipate as a police officer that you may be seeking information, then I would suggest that you would be alerting telecommunications, postal businesses to the need to preserve, but they are the kind of businesses, however, that will have these records and are unlikely to be disposing of them. Sorry, I just picked up on that chat.
All right, thank you. All right, thank you all for your questions. Thank you to our presenters for sharing their time. We will now have a formal vote of thanks from our acting Chief Magistrate, Her Honor Terry-Ann Campbell. So Ms. Campbell, I now invite you to deliver the votes of thanks on behalf of our JEI.
Thank you. I wish to adopt the protocol that has already been established. Good afternoon to you all. In the words of Aesop, gratitude is the sign of noble souls. I deem it a privilege this afternoon to give thanks to all who have made this most enlightening and beneficial learning session a reality. To our presenters, who despite busy schedules have found the time to present to us today. Mr. Andrew Mitchell, King's Counsel, and Mr. Quinn Hawkins. Your detailed and edifying presentation on the Interception of Communications Ordinance is well received and will serve us well. I say thank you to you both. Mr. Rajiv Prasad, your presentation on a most pressing and important topic in these islands, the anti-gang ordinance, is essential at this time and is fitting guidance to us all. I say to you, thank you. We are grateful to the Honorable Chief Justice, the Judicial Education Institute of the Turks and Caicos Islands, our moderator, Mr. Ford. In the words of philosopher William James, there can be no difference anywhere that doesn't make a difference elsewhere. We are therefore thankful for their vision in putting on this seminar on unpacking new legislation. I thank all the distinguished invitees present here for accepting our invitation and participating in this session. I thank you all for your cooperation and attention in making this seminar a resounding success. Thank you.
All right, thank you so much, Acting Chief Magistrate Campbell. So that brings our seminar to a close today. Thank you again to our presenters. Thank you all for attending and for your questions and for making this an engaging and vibrant session. Like I said, this seminar is recorded. It's available to you on request. I've received papers from Mr. Mitchell and Mr. Hawkins. Mr. Prasad has promised his paper shortly. These will be circulated to you. You'll also get a questionnaire from me on the effectiveness of this session. I'll ask you just to take 2 minutes to complete it so we can continue to serve you and your needs as the JEI. So I wish you all a wonderful weekend. Enjoy it. Thank you for joining us. Bye-bye. Thank you. Bye-bye.
Thank you.
Bye-bye.